Let me just first start out that um, certainly, and I'll start with what Miss Apple's comment was that certainly through the use of social media or messaging of various types, one can warn somebody of, I guess, maybe bad service, something that um, occurs at a business. May not be the best way to do it, but fine. That's the way our society is. And some of that, quite frankly, is protected speech. It- the protections on that speech, however,
Buckle up, guys. Today we're going to break down a courtroom moment where free speech collides with its legal limits. The judge starts by acknowledging how social media is often used to warn others about bad business experiences, noting that much of this speech is protected. But right away, the court draws a clear line, emphasizing that protection has boundaries, especially when speech begins to escalate beyond criticism and into something more serious.
are in some ways limited. You can't threaten people. Now, you also have to realize within the context of this that the cat is brought in 40 minutes later, 45 minutes later, whatever it is, the cat is released at the owner's request. After that, I guess one could complain about that service, and that's fine. One could say, that's fine. Some of it regarding the murdering of animals likely.
At this point, the judge walks through the real-world context behind the case. A cat is brought into a business, held for a short time, and then released at the owner's request. Complaints about that service are described as acceptable. However, the court highlights how accusations involving extreme language, like claims of murdering animals, go far beyond normal criticism and begin to expose the speaker to legal consequences.
Is going to result in a lawsuit or could um, because it overreaches. But I'm not here to decide First Amendment libel slander issues or defamation. I'm not here to decide that. Um, at some point, however, the posting of these messages leads to these other contexts. I think defense is wrong. I think it exactly fits within the statute. I also think that certainly at trial, one may be able to argue one's intent. Um, I think, however, that whether one's upset doesn't really matter. If you're upset or whatever, when you start threatening physical harm through the use of some type of incendiary device, that raises this to a whole other level.
Here, the tone shifts as the judge explains why this case crosses into criminal territory. As an outside observer, it's clear the court is focused on how online posts triggered further contact and fear. The judge rejects the defense argument outright, stressing that once messages include threats of physical harm or references to incendiary devices, the situation escalates into a serious public safety issue.
I think it becomes further a problem given, as I was indicating on the record and asking questions about, the sort of access that individuals may have to the business. It is fine afterwards to say, well, that's not what I intended. That's not what you intended. Why'd you say that? Why'd you say those particular things? I think that what's been testified to fits exactly into the statute that Ms. Apple defines, would find that the people have indeed sustained their burden of showing this offense of the unlawful posting of a message, and would bind the defendant over to stand trial on that charge. I'm not adding charges, which I think, given the testimony, I certainly could. And I could certainly add more serious charges because of the defendant's conduct, but I will not. I'm going to decline to do that at this point.
In the final stretch, the judge ties everything together, explaining that intent doesn't erase the impact of threatening words. From the bench, the court finds that the evidence fits the statute and rules the defendant must stand trial. Although more serious charges were possible, the judge chooses restraint, ending on a firm but measured decision.